Hi, welcome to Equal Employment Opportunity and Sexual Harassment Prevention Training for Supervisors and Managers. Hi, I'm Scott Wyman, a Training and Technology Coordinator here at Central Texas College, and I will be your instructor for this course. All right, so we'll start with the purpose of the course. This is pretty easy. Number one, I want to improve supervisor and managers' awareness of discrimination and harassment and how it impedes productivity, morale, and generates negative publicity. We don't want any of that here at CTC. It also generates a legal liability for CTCD, individual managers, supervisors, and employees if action isn't taken at an appropriate time. Well, bottom line is harassment and discrimination are illegal. Our objectives, number one, I want to explain some federal and state EEO laws. We'll also take a look at CTC policies and how those policies relate to those laws in the overall objective of preventing employment discrimination and harassment, including sexual harassment. Also want to explain the expected behaviors and responsibilities of supervisors because we have a little bit different role to play in this than, say, non-supervisory personnel. And of course, I'm here to answer any questions that you may have. Naturally, we're not face-to-face, so you can't just say, hey, Scott, I got a question. But what you can do is you can give me a call or you can shoot me an email. I'll give you my phone number and my email address up here. Feel free to give me a call, okay? All right, rolling right along. We're going to take a look at a couple of definitions. The first definition we're going to look at is unlawful employment discrimination. We word it this way because not all discrimination is unlawful employment discrimination, because discrimination in and of itself is simply distinguishing differences. So the fact that I go out in the garage every morning and jump in my Toyota Tacoma instead of my wife's Honda Civic, that's discrimination against the Civic. But it's not unlawful, and it's definitely not employment discrimination. So unlawful employment discrimination is a behavior which occurs when employment decisions are based on any protected category under state or federal law. Two key parts to this definition. Number one, it must involve an employment decision. Think about all the things you do throughout the course of a day. How many of those could be considered employment decisions? Quite a few, I'm sure. And part two of this that's important, the key part of this, is based on a protected category. And we're going to take a look at the protected categories here in just a little bit. So if you're making employment decisions based on a protected category, you are engaging in unlawful employment discrimination. And that's what we don't want to see here, okay? All right, moving on. Definition number two is unlawful harassment. Now, again, we word it this way because harassment in and of itself is not unlawful. You can harass somebody based on their occupation. Occupation is not a protected category. It's not unlawful. However, if the behavior is repeated, unwelcome, and offensive slurs, jokes, or other oral, written, graphic, or physical conduct relating to any of the protected categories under state or federal law. So again, two key parts. Actually, there's three key parts to this. Okay, make this one a little bit more difficult. Three key parts. Number one, it must be repeated. A single isolated incident does not make unlawful harassment. It must be repeated. Number two is it must be unwelcome. Well, how does somebody know if it's unwelcome? Real simple. If the person being harassed doesn't ask for that behavior, then it's unwelcome. So if I don't tell my coworker to, hey, tell me a religious joke, or tell me a sexual joke, or tell me a racial joke, and they tell me one without me asking, then it's unlawful harassment. If I ask them to tell me a joke, well, then we're both engaging in unlawful harassment if it's repeated. Okay? So you can probably guess what the third key part of this is, right? Based on a protected category. So again, we're going to look at those categories here in just a few minutes. Now, there's two types of sexual, or two types of harassment. Normally, when we're talking about harassment that's not of a sexual nature, we're looking at what's known as a hostile work environment harassment. If you're the victim and what's being done to you creates an intimidating, offensive, or hostile work environment, it's repeated, unwelcome, and of a protected category, then it's unlawful harassment. Okay, so that's the hostile work environment. If it's repeated, and if I come to work every day and Joe comes in every day and tells a religious joke, and I have to listen to it every day because we work in the same place. Well, that's repeated, offensive, of a protected category, and it's creating a hostile work environment for me. Make sense? Okay, good. Moving on then. Well, there we go. I already talked about how unwelcome is expressed. We'll just re-emphasize it here. If it's not verbally asked for by the victim or the person on the receiving end, doesn't have to be the victim. It could be somebody who overhears the conversation or sees the behavior, but it's not part of the direct interaction. Okay? If it's not asked for, then it's unwelcome. So once something is made known that it's welcome, could it then become unwelcome? Absolutely. We have a right to change our mind. I realize that us engaging in this dirty joke telling every day is against CTC policy. I say, you know what? It's time to stop. As soon as I say it's time to stop, if you do it again, well, now it becomes repeated. I told you to stop, so it's unwelcome. So repeated, unwelcome, and well, if it's a sexual joke, then it's based on a protected category. So as supervisors, we need to look out for certain clues that may be presented to us just as we're doing our daily business. You want to listen for comments such as, I don't like it when he does X, Y, and Z. Well, what exactly is X, Y, and Z? Well, that's what you need to find out. Or, I sure wish she would stop doing this or saying that. Well, what exactly is she doing or saying? You need to look into these things. Or somebody says, that's not appropriate for the workplace. I think you need to stop. You as the supervisor, if you heard that, you need to step in and say, all right, what's going on? What we said is inappropriate. Then you can re-emphasize, yes, that's inappropriate for the workplace. If it happens again, it's repeated, and that makes unwelcome, unlawful harassment. So we need to make sure it stops. Or somebody says it makes me uncomfortable when this is done or when this is said. That's creating that intimidating, hostile, or offensive work environment. As supervisors, it's our job to prevent that kind of stuff from happening. It's our job to provide a work environment that's free from harassment, discrimination. I think it says that in a policy somewhere. We're going to take a look here in a little bit. All right, federal laws. There are quite a few federal laws in place to protect us, right? I don't care who you are. These laws are in place to protect everybody. There's nobody that works at CTC who doesn't fall under one or more of the protected categories. So if they fall under those categories, then they could be harassed or discriminated against because of those. So these laws prohibit employment discrimination, and they cover personnel decisions that could affect an employee's or applicant's employment opportunities. So even the folks out there filling out applications, they're protected just like the rest of us are. So let's just take a look at some numbers. I like numbers. Numbers really tend to paint a picture. These are numbers of complaints filed nationwide, right? This isn't just here at CTC. Nationwide with the EEOC. And I went back to 2011. The reason I go back to 2011, well, because that's the year that we had the highest number of complaints filed in Washington. In 2011, 99,947 people felt that they were being treated unfairly at work for one reason or another. I hope we never see 100,000. But the numbers go up, they go down, they go up, they go down. So it's hard to tell. But hopefully through education, the more people know, the more people understand that your behavior at work, there are certain things that are expected and certain things that shouldn't happen. We just need to make sure that we do our part so that it doesn't happen here at CTC. Okay, so they don't have the numbers out for 2023 yet. Probably have those out for the next time I make these recordings. But the lowest number of complaints filed was actually in 2021. Now, I don't know for sure, but I think that might have something to do with COVID. All right? There were fewer people at work in 20 and 21. So I think that's probably why the number of complaints were less. All right. So discrimination complaints here at CTC in our EEO office with Jackie Thomas. I only go back to 2015. I don't want to, go too far back, but you can see in 2015, the number of complaints filed were 22. In 2016, there were 18. 2017, I'm not sure what happened in 2017, but it jumped up to 60. And in 2018, it dropped down to 28. And then you can see 2019, it was 18, 2020, 21, 22 numbers very low, which is good. But again, I think that might have something to do with COVID. Okay. Now, let me point out, in 2018, there were 28 complaints filed in Jackie's office. And I use this one as an example just because, because I know the numbers for this one. Of those 28 complaints filed in Jackie Thomas's EEO office, right? Of those 28, 2 were based on a protected category. The other 26 had nothing to do with equal employment opportunity or unlawful harassment. Now, I'm not going to get into the details. I don't know all the details, but let me tell you, there were some complaints that just absolutely had no reason to be taken to Jackie Thomas's office. That's what we're here for. If there's something going on in the office and we can do something about it, then that's our job to do something about it. Don't say with every issue, with every complaint, "Oh, go file a complaint with Jackie. That's her job." No, it's not. Her job is equal employment opportunity, not whose trash can we should be using or what should we be doing before work. EEO. EEO complaints go to EEO. Non-EEO complaints come to us, the supervisors. That's why we get paid, not big bucks, but mediocre bucks, okay? Hold up your end of the bargain. Make sure your folks have a comfortable place to work. All right, so here are the protected categories, the first 5, okay? The first 5 protected categories come from Title VII of the Civil Rights Act of 1964, which in and itself set the standard to prevent harassment and discrimination in the workplace. And these 5 categories, race, religion, sex, color, and national origin, those are the 5 protected categories that they decided people should not be treated unfairly or differently because of. And there you can see the definitions. The definition of race, that's just one I picked up. There are hundreds of different definitions for race. Title VII doesn't specify what race is. Religion, well, there are thousands of different religions in the world today. We don't prohibit people from discussing religion at work. We don't encourage people to discuss religion at work. My big thing with talking about religion at work is before you open your mouth, open your mind, because you never know what's going to come out of the other person's mouth. If you don't know them well and you don't know their religion, they might come out with a religion that is vastly different than yours. So if you're willing to open your mouth about religion at work, You need to be accepting of what the other person says. All right, enough about religion. Color is simply the color of your skin, pigmentation. So people of the same race can be different colors. National origin is an individual's place of birth. That applies more or less to first-generation immigrants. If you're a second or subsequent generation, then it's your family's country of origin or countries. Okay? And then sex. Sex does include gender. So you've got male and female, and then we also have the social construct of masculine and feminine. And normally there's not an issue as long as males are masculine and females are feminine. But what happens when you get a feminine male or a masculine female? Well, that starts to send people's mind to reeling. Well, that ain't right. Men are supposed to be masculine and females are supposed to be feminine. There must be something wrong with these people. No, there's nothing wrong with them. They're just different. And different is okay. Believe it or not, all men have some feminine tendencies. And all females, all women have some masculine tendencies. And that's okay. Different is good. Different races, different religions, different colors, different national origins. There's so much to learn from all of these differences. And that's what we need to encourage. Encourage open communication. Encourage your folks to get to know each other. Maybe not as deep friends or close-knit friends, but get to know each other as coworkers. You don't even have to like the other person, but getting to know them might make it easier working beside them. All right, so that's Title VII of the Civil Rights Act of 1964. There are other protected categories not listed in Title VII, but under other laws and policies that have been enacted over time. So based on CTC's policy on anti-discrimination and harassment, these also are protected categories: veteran status, genetic information, sexual orientation, gender identity, and transgender status. So those last three, you can see where when you get the different social constructs not matching, that's where issues can arise. But it's okay for women to wear men's clothes and men to wear women's clothes, even coming to work at CTC. There's nothing in our dress code policy that says men can't wear skirts or dresses. And there's nothing in the policy that says women can't wear pants. So again, just because somebody's different doesn't mean they're wrong. It simply means they're different. Tolerance, acceptance, and understanding. 3 words I like to live by. Tolerate different behavior. Again, because we're all different. Some different behavior could be a good learning experience. So tolerate different behavior. Never tolerate bad behavior, but tolerate different behavior. Accept others for who they are, not who you think they should be based on your beliefs, your values, and the way you see the world. Accept them for who they are, because they are them and you are you. And we're different, and that's okay. And then understanding. Seek to understand why they do the things they do. Why are they different? What drives them? The more you get to know somebody, the more you understand their behaviors, and the easier it'll be to accept them and tolerate the different behaviors. So, tolerance, acceptance, and understanding. Three words that I like to live by. All right, Title VII of the Civil Rights Act of 1964 also prohibits retaliation against an employee who opposes discrimination or a person assisting in the investigation of a complaint of employment discrimination. So anybody and everybody involved in the complaint process, the complainant, the witnesses, the investigating officers, even the alleged offender are protected against retaliation. And if you're not sure what retaliation is, retaliation in general is taking some sort of negative action against a person for doing what they did. So if you start micromanaging somebody after they file a complaint, but you didn't do that before they filed a complaint, that could be considered retaliation. Or if you move them from this workplace to that workplace because they filed a complaint, that's retaliation. Even if it's in their best interest to move them out of this office and into another office, that could be considered retaliation. And we'll see some more of that here in just a bit. Another part of this that's important for us as supervisors is this statement where it says the employer is liable if it knew or should have known about the conduct and failed to take immediate investigative and appropriate action. So if you know somebody in your workplace is behaving badly, and if it's in violation of one of these policies or laws based on a protected category, and you fail to take action, then you're guilty as well. You should have known, or you knew. Or if you should have known, how should I have known? Well, if you know somebody filed a complaint, if you notice that the behavior between certain individuals has changed drastically, if you hear people mumbling and talking about somebody's bad behavior, you should have known. So we have to take this seriously as supervisors. All right, Title VII of the Civil Rights Act of 1964 says you have 180 days from the time an incident occurs to file a complaint. The EEOC in Washington, D.C., well, they've extended that time. They figure if you're going to file a complaint with them, a federal level complaint, then we'll give you 300 days to file the complaint. I tell folks in my non-supervisor class, don't wait 300 days to file a complaint. Don't wait 180 days to file a complaint. You know how much people can forget in 6 months' time? If something happens and you believe you're the victim of harassment or discrimination, you need to, number one, document. Document. Who, what, when, where, why, and how it made you feel. Those are the 6 keys to filing a complaint, okay? Who, what, when, where, why, and how it made you feel. And then you report that behavior, okay? If it's harassment, you don't have to wait until it's repeated. One inappropriate action should be reported. Now, where and at what level you report it, that's up to the person who's doing or who's filing the complaint or who's reporting the bad behavior. The best first place to report is the person doing the bad behavior. Just say, hey, you know, I don't appreciate what you just said. Please don't say it again. Or I don't appreciate what you did. It makes me feel uncomfortable. That's reporting. And hopefully that person will stop doing what it was they were doing. All right, hopefully. If they're not comfortable going to that person, then they should go to their supervisor, you. Now it's your job to take action. You should tell the individual who's filing the complaint or who's reporting the bad behavior, I understand, and I'm going to take appropriate action. And then you go talk to the person who did the bad behavior. You say, hey, somebody said they don't appreciate what you did or what you said. Don't do it again. You don't have to tell them who reported it. Just say, hey, I heard that you did this, or I heard that you said that. Don't do it again. You're not accusing them of doing it. You're just saying, I heard that you did it. Don't do it again. And then document that as the supervisor. You need to document it. If it was a violation of EEO policy, you need to call Jackie. Okay, if somebody comes to you with allegations of discrimination or harassment, and it's based on any of the protected categories, you should call Jackie for advice. She may just take over and do the investigation herself. But it needs to be addressed. The worst thing you can do as a supervisor is blow it off. You take the information from the person who's reporting the bad behavior and then just tuck it away somewhere. Because guess what? If it happens again, you knew that there was a situation and you failed to take action. That makes you guilty. All right, so that's the new, or should have known, and a time limit, 180 days and 300 days. Again, if you have any questions on this, feel free to give me a call. You can give Jackie a call. She'll help you out. She's got all the answers, just like, well, she probably has more answers than I do, because that's her job to do the investigation. I just teach this stuff. All right, your responsibilities, real easy. Apply these standards equally. Make sure anybody and everybody who violates the policies gets the same treatment. Take all complaints seriously, kind of like I was just talking about, and then notify HR to help out with the process. Not every complaint or not every report has to be a complaint. If there's something you can do right then and there to stop the behavior, then do what you need to do to stop the behavior. Call Jackie, say, hey, this was reported, this is what I did. Do I need to do anything else? But you're a supervisor. You have the power to administer discipline. So when somebody violates the policy, you need to take action. Never retaliate against those who file a complaint. That's one of the worst things you can do. And make sure all your folks attend the required training. I got to give you all credit. The number of folks who are beyond their required training date has gotten a lot smaller in the past years. And I give you all credit for that, because without your help, we couldn't make this happen. So just make sure that you keep enforcing the policies. This is part of the policy, right? Policy 220 says that we're supposed to attend this training within 30 days of hire and then every 2 years after that. So just make sure you do your part. Make sure you give your folks time. If they want to do this online and watch my videos, give them time to watch the videos at work. Don't make them do it at home. That's just rude. Give them time to do it at work. If they attend the face-to-face, they would take way more time out of their day than they would sitting down to watch these videos. So give them time. Give them time. All right, the next law that we're going to take a look at is the Equal Pay Act of 1963. This one's pretty simple. It prohibits discrimination in pay based on gender when the job circumstances are the same. So you got a man and a woman doing the same job. They should be getting the same pay. However, if one has more education, that's grounds for or justification for more pay. If one has more experience, that's justification for more pay. But if they're doing the exact same thing, they have the exact same experience, the exact same education, they should get the exact same pay. We don't have to worry about this at CTC because we all work off a pay scale. Clerk 1 is a clerk 1. Easy schmeezy, okay? But there are circumstances, there are times when what if you don't know how much your coworkers are making? Some employers make their employees sign a document of non-disclosure saying they won't discuss their pay with other employees. And if they do, it may be grounds for termination. I had a job like that once. And you have to take that kind of stuff seriously. I'm not going to jeopardize my job just because somebody wants to know if I'm making more money than they are. But there was a woman who worked for Goodyear. She was a production floor supervisor in their Mississippi plant. This is her right here, Lily Ledbetter. After she retired, she found out she was getting paid less than her male counterparts, her male peers. So she went to the EEOC and said, hey, EEOC, this isn't right. I should have gotten more money. The EEOC said, you're right, Lily, let's take Goodyear to court. So they took Goodyear to court. The court said, Goodyear, give her $2 million because you did her wrong. Goodyear said, don't you spend any of our money because we're going to get it back. And they did. They went to the appeals court. The appeals court, after hearing their argument of, well, it's been way more than 180 days since she agreed upon a salary, and that's the day in question when we're talking about pay. Appeals court said, oh, you're right, give her the money back, or give Goodyear the money back. EEOC said, you know what, Lily, that just ain't right. Come to Washington, help us lobby for this Fair Pay Act of 2009. So she went to Washington and she lobbied and lobbied and lobbied. And all her lobbying paid off because, you know what? In February of 2009, President Obama signed into law the Lilly Ledbetter Fair Pay Act of 2009. She has a law named after her. How cool is that? What this new law does, what the Fair Pay Act of 2009 does, in a nutshell, is it resets that 180 days every time you get paid, because they consider you getting a paycheck negotiation for pay. Because if you're not happy with that paycheck, you can go to your boss and say, hey, boss, I need more money. They might say no, but you can do that, and that's negotiation. Or if you get your paycheck, say, oh, that looks really good, I'm satisfied with that. There's your negotiation. You're not going to go ask for more pay. The negotiation is done. So now that 180 days resets every time you get paid. So you'll never run out of time to file a complaint of unequal pay. Then we have the Age Discrimination Employment Act of 1967. This one also has a bit of a twist to it that some people like and some people don't like. This law prohibits discrimination by public and private employers in all personnel decisions because of a person's age. However, you must be at least 40 before you can file a complaint under the Age Discrimination Employment Act. If you're 38 and you think you've been discriminated against because of your age, sorry, can't happen. You can be harassed based on your age. Age-based harassment happens all the time. Just look around. Look how many generations of employees we have. We have generation after generation after generation. In some places, we have as much as 4 different generations working in the same place. Think about the differences between the generations. What was it like back in the day? What kind of expectations do they bring to the job? Think about how the younger generations view their job. Those are things that we have to take into consideration. And we don't want to be harassing people based on their age. Good enough? Good enough. Moving on. Then we have the Americans with Disabilities Act. This one's big. I mean big. And it gets bigger. This act prohibits discrimination by employers in personnel decisions based on mental or physical disability. So 2 different types of disabilities, mental or physical. And basically what happens is a person's impairment must meet the definition of a disability. So it has to meet one of these 3 bullet statements. Any one of these 3. Number 1, if it limits one or more major life activity. What is a major life activity? Well, let me tell you. A major life activity is an activity that a non-impaired or non-disabled person can perform with little or no difficulty. Things such as walking and reaching and bending and talking and looking and listening. Okay? It's just the basic things that we do on a regular basis that we don't even stop and think about. So if the person has an impairment that limits one or more of those major life activities, then they have the grounds to file under the Americans with Disabilities Act. Or if they have a record of an impairment, maybe their impairment isn't outwardly visible. Okay, they don't wear hearing aids, or they don't wear glasses, or they don't go around in a wheelchair or crutches. Okay, but they have an impairment that may occur. Cancer, epilepsy, things like that, things that you can't see but may require additional doctor's notes, additional doctor's appointments, additional time off for whatever. Or maybe they need some sort of special equipment. That goes for either one of these two. We'll talk about that in about 30 seconds. But let me tell you about the third one. If the individual is regarded as having an impairment. Now, for the first two, the employee has to come forward and self-disclose. If an employee doesn't tell you they have an impairment or they don't have a disability, but you treat them as if they do, they can file a complaint under the ADA. So again, we will make sure we treat everybody the same. Everybody's hired to do their jobs. If they need some sort of special equipment, well, after the employee self-discloses, I missed one here. After the employee self-discloses, well, then it's the employer's job to provide reasonable workplace accommodation. What's the degree of reasonability? That's based on money. Can CTC afford to purchase whatever it is they need to give them the opportunity to perform up to the standards of a person without a disability? They need a special monitor, maybe a computer program, maybe some sort of desk or chair. But if they need an elevator to get to the second floor of a building that doesn't have an elevator, that's not reasonable. In that situation, what you would do is you would take the office from the second floor and move it to the first floor so that that person with the disability can access their office. And then you would take whoever was in the first floor office, move them to the second floor office. That's accommodation. Easy. Easy. All right. Now, in 2008, President Bush signed into law the Americans with Disabilities Act, Amendments Act of 2008. And what this new act did is it expanded on the term disability. It looks at what's considered a major life activity in a whole different light. The first list includes, many of the things that I already mentioned, the walking and the talking and that kind of stuff. It's the second list, right? These are non-exhaustive lists. The second list is the big one. This is the one that includes major bodily functions to include normal cell growth, the immune system, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and even reproductive functions. So if you have an employee, or maybe you have an impairment based on any of these listed major bodily functions, and you need more time off work or more time for doctor's appointments or whatever the case may be, you come to work with a note from your healthcare provider that says what your impairment is and what sort of accommodation you need. And then CTC, it's their responsibility to do whatever they can do to make sure you have all the opportunities to perform up to the same standard as everybody else. Look, there it is. I got ahead of myself. Sorry. But that's what I was talking about. Okay. The employer has the affirmative duty to make reasonable workplace accommodations that does not constitute undue hardship. Right? So CTC is not going to spend their entire bank account putting an elevator into a building just so one of your employees can get to the second floor. No, that's unreasonable. It would create hardship on the college. So again, it's your job. If an employee comes to you with that note from their healthcare provider that says they need workplace accommodation, don't just blow them off. Don't say, oh, you work like everybody else does. No, wrong answer. Pick up the phone, you call Jackie Thomas. Hey, Jackie, I have an employee here that needs workplace accommodation. At that point, Jackie will initiate what's called the interactive process. Okay, she'll sit down with the employee, she'll look at the note, she'll get with the departments and budget, and they'll work out a way to purchase whatever it is that that employee needs, as long as it doesn't create undue hardship on the college. All right, so those were the federal laws. Texas has laws in place as well. Down in Austin, we have the Texas Workforce Commission, and within the Workforce Commission, we have the Civil Rights Division. And it's their job to enforce the Texas Commission on Human Rights Act. And it's this Texas Commission on Human Rights Act that essentially, well, it's Title VII for Texas. Okay, the TCHRA is the Texas equivalent of Title VII. But it lists more than just 5 protected categories. The TCHRA prohibits employment discrimination in all personnel decisions based on a person's race, color, disability, religion, gender, national origin, age, and it also protects against retaliation. Okay? And then, of course, the federal and state laws have also been expanded to include sexual preference, sexual orientation, gender identity, and transgender status. All protected categories. Let's take a look at Policy 220. We're going to take a look at Policy 210 as well. I won't cover 210 as deeply as I do 220. All right, so all these policies can be found on CTC's faculty and staff website. Just go to Human Resources and then look for the Policies and Procedures Manual. So really, this is fairly simple, right? The purpose of this policy is just to make sure that everybody has an opportunity and an avenue to file complaints if they believe they're being treated unfairly, or if they see inappropriate behavior in the workplace, they can follow these same procedures. Policy applies to everybody on CTC campus: employees, students, vendors, contractors, visitors. So if you have a group or a vendor that comes on campus, make sure they understand that CTC has a policy against discrimination and harassment. All right, so definitions, these are the same definitions that we've already talked about, with the exception of this first one, and we'll talk about this one in part 2 of this video. Okay, this is part 1. I'll do sexual harassment, sexual assault, sexual misconduct in part 2. So I'm going to bypass that one for right now, and we'll move on. There's a definition of unlawful harassment that we discussed. There's a definition of discrimination, hostile work environment. So here are, again, CTC's, the policy. Discrimination is a behavior which occurs when employment decisions are based on an employee's, and here are the protected categories: race, color, religion, national origin, gender, age, disability, veteran status, genetic information, sexual orientation, gender identity, or transgender status. All protected categories, or any other category under state or federal law. Okay? All right, the policy itself. Harassment, assault, or discrimination in violation of this policy or any state or federal law is not tolerated. It is CTCD's policy that all employees should enjoy a work environment free from harassment and discrimination. And guess what? I mentioned earlier, it's your job to provide that environment. If you see something happening that disrupts the peace and harmony of your area, it's your job to put a stop to it. Because we should all be able to work in an environment that's free from harassment, discrimination based on any category, whether it's protected or not. If somebody's made to feel uncomfortable, or they're offended or intimidated, then it needs to stop. This policy is rigorously enforced throughout CTCD. Immediate and appropriate discipline up to and including termination of employment will be imposed on any employee found guilty of harassment or discrimination. Allegations will be fully investigated. Right? Every allegation that goes to Jackie Thomas will be investigated. So anytime you get something, a report to you that has to do with any of the protected categories, you should be on the phone with Jackie. It's important that you and the folks who report to you understand that confidentiality will be maintained to the extent possible. And they also need to understand that they don't have a need to know exactly what's happening during a complaint process. Even when it's done, they're not going to get all the gory details of what was happening. They don't need to know who all was interviewed or what they said. They don't have a need to know what action was taken against the person who they reported. The best thing that they're going to find out, and you shouldn't tell them any different, is that your allegations were investigated and appropriate action was taken. Because they don't have a legal need to know. We punish in private, we praise in public. So they don't need to know what happens, what discipline is administered. CTCD and its employees shall not retaliate against any person, employee, or student who in good faith, and that's a very good statement right there, in good faith, reports perceived harassment or discrimination. So two key parts to this here, right? In good faith and perceived. If they're making stuff up and reporting it just to try and get somebody else in trouble, well, there's another policy that addresses that, and we'll see that here in just a minute, okay? And then perception, just because you're not offended or you don't think something is inappropriate for the workplace doesn't mean they don't. And when they report inappropriate behavior, it's their perception. Who, what, when, where, why, and how it made them feel, right? Not who, what, when, where, why, and how it made you feel. It's their perception. If they believe they're being harassed, then it's your job to stop that bad behavior. And if it's based on a protected category, well, if it's unlawful, then we get with Jackie, and Jackie's going to help out with that situation. All right, paragraph D there just talks about the training requirements. I already talked about that. This is an important part. Any employee who believes that a supervisor, manager, other employee, or non-employee's actions or words constitute unwelcome harassment or discrimination has a responsibility to report or complain about the situation as soon as possible. What's the important part about that one? Well, it's important that they understand that they have a responsibility to report or complain as soon as possible. You have a responsibility to report or complain as soon as possible. If you see something that's inappropriate, report it. Again, what's the best place to report it? Go to the person who did the bad behavior. You, as a supervisor, has the power to administer discipline. Check out our policy on progressive discipline if you're not sure. Call Jackie and say, hey, how do I go about administering discipline when I see inappropriate behavior in the workplace? She'll help you out. It even goes on to say that since allegations are addressed or best resolved at the lowest possible level, they encourage you or the person doing the reporting to go to the person who acted or behaved in a harassing or discriminatory manner. And if they're not comfortable with that, well, then they can go to their supervisor or the next level supervisor if the supervisor is the issue. They shouldn't be afraid to come to you with allegations or with reports of inappropriate behavior. You shouldn't be offended if they go above your head to report allegations of inappropriate behavior. And remember, don't retaliate just because they go above your head. All right. Yeah, they can also come straight to HR if they believe they need to. But again, hopefully they understand and y'all understand that if it's not EEO related, then it shouldn't be brought to HR, or at least not EEO. Okay, let's use the supervisory chain for what it's there for. It's not just there so that people in other positions can make more money. The supervisory chain is there to make sure that everything runs smoothly. All right, this section here, I can't foot stomp enough. I can't say this isn't happening, but I can say I want to see this happen more. Again, this is in the policy. Supervisors and managers will, not should, not might, not could, but will cover this subject area annually as part of a continuing education program for employees. What does that mean? Does that mean you have to stand up and give this whole presentation like I'm giving now? No. You can stand up and go through the policy like I'm doing now. Emphasize a few key parts like I just did. Foot stomp when you need to foot stomp. But the best way to keep this ship running smoothly is to make sure that everybody knows what they should and shouldn't be doing. And if you need help, give me a call. Here's my phone number. Here's my email address. Let me know. I make house calls. I'll come to your department and go over the policy like I just did. And that'll be your yearly review. Make it happen. All right, so now let's take a look at Policy 210. Policy 210 is our grievance procedure policy. I'm just going to kind of outline this. I'm not going to go through the whole thing in great detail like I did Policy 220. But please refer to the HR Policies and Procedures Manual to get detailed information. And if you have any questions, feel free to give either me a call or HR a call, Jackie Thomas, or maybe even Holly. All right, so the purpose naturally is to provide a mechanism for employees to discuss complaints or problems with management and to ensure fairness and consistency in CTCD's relations with its employees. This policy, like most other policies we have, applies to all CTCD employees at all locations. The policy itself, all employees of CTCD are provided the opportunity to file a complaint related to a condition of employment or application of a policy that the employee feels is unjust or inequitable. With the exception of full-time faculty, former employees are not eligible to file a grievance. CTC does not engage with or allow participation of third parties regarding internal employee matters. All right, so here's the outline portion. It's kind of the Reader's Digest condensed version. The reason I do this is because there are a lot of time constraints on this. You have a certain amount of days after this happens to do this, and you have a certain number of days after this happens to do that. And HR has a certain number of days after this to do that, okay? So that's kind of why I condensed this. But we always encourage resolution at the informal level. And the best way to do that is for the person with the problem or with the issue, they should discuss it with the individual that they're having the issue or the problem with. If it's not resolved at that level, then the employee with the grievance can discuss the issue with their immediate supervisor or next higher level, department head, dean, or associate vice chancellor if the issue is with the immediate supervisor. And of course, you can always go straight to HR if you're not comfortable addressing these issues with your chain of command. But we do encourage using a chain of command. Let your supervision do what they're in place to do, and that's to provide you with a work environment that's cohesive to you getting your job done, okay? If the grievance is not satisfactorily resolved at the lower level, the grievant may discuss the issue with the Chief Human Resource Officer or his or her designee within 15 calendar days of the first attempt at resolution. All right, so there's our first time constraint, 15 days within the first attempt. So if you go to the individual who you're having the issue with, and after 14 days, the issue hasn't been resolved, beat feet to HR and file your grievance with the Chief Human Resource Officer, because you only have 15 days after the date that you tried to resolve it at the lower level. So when you do go to HR, they're most likely going to request a written statement and any recommended resolution that the grievant may have. Because if they can resolve the issue and come to the resolution that the grievant is looking for, then all the better. Okay? Understand that an investigation will be conducted. I mentioned earlier, everything that goes to Jackie Thomas's office gets investigated. Or if I didn't mention that earlier, I'll mention it later. Once the investigation is complete, both parties will be briefed on the outcome. Again, they're not going to get the details. They're going to say, your allegations have been addressed and appropriate action has been taken. Okay? If the grievant is still not satisfied with the resolution and wishes further review, the employee may request an examination of the issue by a review committee, and they have to do this in writing to the Chief Human Resource Officer. This request must be made within 15 calendar days of when they were notified by HR that their investigation was complete. All right, so 15 days and then 15 days. Got to watch those time constraints. If you go beyond that 15 days, then it's done, over. Once that request for review committee has been received, the Chief Human Resource Officer within 5 days will form a review committee. That committee will include the executive officer in a chain of command of the grievant, along with 2 deans or associate vice chancellors. The committee will provide findings to both parties within 15 calendar days, so the committee will have 15 days to come to a resolution. If the grievant is a direct report to the chancellor, then a mediation service will be brought in as opposed to a review committee. If the grievant is still not satisfied, they may submit a letter of appeal to the Vice Chancellor Finance and Administration, who will then forward that information to the chancellor for review. The chancellor or his or her designee will make a determination and notify both parties of what the final decision was. Confidentiality should not and cannot be granted. Now understand that this decision by the chancellor is final. There is no appeal process for that, okay? Full-time faculty or instructors can present a grievance to the vice chancellor over who oversees them, I guess is a way to put it. Faculty grievance process will include the review and appeal steps that was previously reviewed. Now, this is a very, very important part of this policy 210 for grievance procedures. I mentioned a while back talking about policy 220, where it says that people should file complaints in good faith. And that's what this addresses. Any employee who knowingly files or should have known of the likelihood that they are filing a false or unwarranted complaint in an attempt to attack or discredit another employee, or that disrupts the operation of CTCD, may be subject to discipline up to and including termination. This is known as filing a frivolous complaint. So I mentioned earlier not to use this system as a vengeance tool. Don't use it to try and get somebody in trouble that you don't like. Because if it's found out through the investigation that your allegations were all false and you made it up, or a person made it up, not you, the supervisor, then appropriate disciplinary action will be taken. All right, so again, if you have questions, give me a call, shoot me an email. My information is up here. And unfortunately, we haven't seen a passkey for this. So you're going to have to watch part 2. So somewhere in part 2, I'm going to have a passkey. Also keep in mind that until we receive your training completion form, you don't get credit for this course. Okay? So you watch the first part, you're still alive. Watch the second part, you'll survive. And then take the pass key that you get, apply that to your training completion certificate, training completion form in eTrieve. Make sure you look for the right one, okay? And I'll talk about this at the end of part 2. So I'm going to say with that, thanks for being here. I appreciate your time. Stay safe, stay healthy, and stay happy. And we'll talk to you later.